Okay, good afternoon, everyone. My name is Christophe Carugati. I am a senior policy analyst at the Center for Data Innovation at think tank, working on digital issues. We will do today a seminar, a public event on what should enforce the EU Digital Services Act. So, you know, it's a big piece of legislation, part of the digital single package. And the goal is to control illegal content. And here we will speak about a big part before the Commission and also before the Parliament about enforcement. You know, it's a big issues and it's a bottleneck basically here, and where we have some friction between member states on who should enforce the Digital Services Act. So to introduce this topic, and we will do it with three interesting speakers. First, Camilio from DG Connect, Enrico Camilli, I'm sorry, from DG Connect, Manonta Baczynski from Ali for Startup, and Venus Ali from Digital Future Forum. The panel will be in three parts. Part one will be on the DSA enforcement framework. Part two will be on the role of the member state in the Commission. And part three will be on how the European Parliament should address the enforcement issue here. So my first question is to you, Enrico Camilli from DG Connect. I know you know a little bit the topic. So what is the Commission proposed enforcement framework on this topic, on the DSA?
Thank you. Good afternoon, all. Thank you, Christophe, for your question. Indeed, I think it's helpful to give an overview of the pillars that were underpinning the Commission proposals. The DSA is a regulatory framework that covers all kinds of platforms and intermediary services, and it is generally applicable. So it has a very broad scope. For this reason, the enforcement framework or structure has been very much influenced by this approach, and it has several consequences. First of all, it's in the Commission proposal, the role of national authorities is very important. This is a difference, for instance, with DMA, where it was more a Commission role in the proposal stressed. Second point, the architecture of public enforcement, which is foreseen in the proposal, is focusing on the scrutiny of system and processes put in place by platforms. And this is also something very important, not really to the assessment of each individual item of illegal content. Exactly because it concerns processes put in place by platforms, it was extremely important to identify clear allocation of competencies, and the basis is indeed the country of origin, so that the processes of platforms to moderate content and to tackle illegal content is to be assessed in a centralized manner by the authorities in the country of origin of the platform. Fourth point I would stress is that the architecture of the DSA gives a lot of flexibility to member states on how to organize internally the function, the public enforcement function, with two important points. One is the need for independency of authorities, which will have to implement those rules. The other is that there is need of a clear coordination and contact point in each member state to ensure that cross-border cooperation and European cooperation can work with clearly identified actors. And then the last point, which I would like to stress of the Commission proposal, is that it is a mutual cooperation framework. So national layers, different member state authorities in different member states, and even within a member state, they have to cooperate. We want to leverage as much as possible on the existing competencies in scrutinizing content moderation processes, but also at European level, this is extremely important. That's why we thought to a cooperative system of enforcement, which foresaw the role of the European layer as a supplementary and complementary role to the national authority when this is needed because of the cross-border nature, because of the complexity of the issue, the possibility for the board, but also the Commission to directly intervene on specific issues, in particular those that concern blobs, is one of the peculiarities of the DSA proposal, which indeed foresee a role of the Commission also as an enforcer, but in a residual role, as a help to the national authorities, which remain, in any case, the main actors.
So thank you, Nico. So you say that it's the role of national authorities is very important in the enforcement of the DSA, at least in the Commission proposal here. But so it's important from a regulatory perspective. But what about the firm perspective? And I will ask this question to Manon. She's working at Allied for Startup, and why does this enforcement framework in the end of national authorities and to some extent to the Commission for very large on the platform at least is important for businesses and especially startups?
Thanks for that. Thanks, Christophe. Hello, everyone. Good afternoon. As Christophe mentioned, I work at Life for Startups. Just briefly to introduce ourselves, Life for Startups, we are an umbrella organization of startup associations. We have 45 members that are all over the world, so from Startup Canada to Startup Malaysia, and we have a lot of members also in Europe. And our mission also is to make sure that the startups, they have the right regulatory framework they need to start their business, but also scale it. And as my presence here can show it, DSA is one of our top priority. And in DSA, specifically the controversion principle and the enforcement. And so to reply to your question, Christophe, for us, the controversion principle is really a top priority. When a startup launches business, they want to be, the startup entrepreneur that wants to be compliant with the law regulating its business, but also partly of this means to have clarity regarding risk when they go cross-border. And so the controversion principle, as proven in the eCommerce Directive, has really given startups the legal certainty that they need to operate cross-border, to be the global businesses that they want to do also, and to test their innovation, product or services in several EU markets. So the fact of having also one single point of contact, or knowing that you will respond to the authority in the member state where you are located or where you are your headquarters, is for us a strength in the digital single market, and it should be preserved. It's one of our top priorities, as I mentioned. We also believe that not having a controversion enforcement system would also mean for startups that they would have to have a shop in all the member states, so in opening a shop in 27 member states in Europe, and it would cost for them a lot of resources. So that's maybe one part of my answer to this. I mean, I could go along and along. I don't know if you want me to precise something or not at this stage. I think you're muted, Christophe.
I think I love these sentences you are muted. Yeah, the country of origin for you is very important because otherwise it will cost a lot of money to start up and cross-border. But the question is, how do you take into account also the interest of some, I would say, member state to control what is illegal in one country may not be illegal in another country. It's a fact. And what is your answer to this question here? And Enrico, perhaps you can contribute also after as a follow-up. Venus, of course, you can contribute also if you have a word on this.
Yeah, hi. Thank you very much for your question, Christoph. And thank you for organising this panel discussion. I think it couldn't come at a more timely moment. So just a little bit about, I guess, Digital Future for Europe before we get into the detail of this. So Digital Future for Europe is a coalition of startups and scale-ups from across the digital frontrunner nations in Europe. We have over 100 members, and the DSA, as you can imagine, similar to Manon, is of extreme importance to us. I think I'll just start by sort of giving you a few facts. So we, at the start of this year, surveyed our members to try and understand better what they felt how the regulatory framework served them currently. Only 5% of the respondents to that survey said that they thought that the EU understood the needs of startups and scale-ups. 53% already found it quite difficult to navigate an ever-changing landscape of regulations. And this perhaps is most important to this discussion. 30% of our supporters who filled in this questionnaire said that they already encounter barriers to selling across the EU. And often those barriers take the form of understanding the rules in different member states. And so any regulation that looks to harmonise across member states is something that startups will want to see. And I think, as Manon said, the country of origin principle is extremely important to startups who do not have either the in-house expertise to navigate many different member states' legal frameworks and regulatory frameworks, nor do they have the ability, as Manon alluded to simply set up in every member state. And yet we want to be able to reach 500 million consumers and citizens from wherever entrepreneur decides to base themselves. So it's extremely important to get this right. And I think this differentiated approach that's being proposed now by the presidency of having VLOPs regulated centrally by the Commission in many ways offers greater certainty and clarity to the largest players who are able to absorb the sort of the navigation of different frameworks than it does to startups who, as you say, may still be faced with, where something's illegal in one country and not in another. So that's really important to bear in mind. And I think, to Enrico's point, we really do want to see good coordination and cooperation between member states, so that we don't essentially have startups in the middle. And it would be great to have greater clarity of exactly what does that cooperation look like, and exactly how these different coordinators will work together.
Perhaps, Enrico, if you have some words on these issues, it would be a good introduction to the next part, which is the role of the member state and the Commission following the Parliament proposal, because we know that the Commission would basically enforce for, very large online platforms, but this poses an issue because, like I said, what is illegal in one country may not be illegal in another country, and for some, it will have very important legal consequences, I guess. So I know you cannot disclose your view, but if you can at least have some words on that, it would be grateful.
Mm-hmm. Yes. So how cooperation will work, and also your question about what is illegal in one country but is not in another. Now, the basic framework of the e-commerce directive, which is based on the country of origin principle, is not changed by the DSA, and it is actually strengthened. with regard to the DSA obligation. Unlike the e-commerce directive, for the enforcement of the DSA obligations, there is no possibility of derogation to the country of origin principle. So only and in particular for startups, because the changes that are being discussed in council, as you pointed out, are referring to the role to the VLOPs, but for all, which is a very small subset of the thousands of platforms which are active in Europe. So the enforcement of the DSA obligations will only be possible for the country of origin, no possibility of derogation. But at the same time, because of course this is, and the rules that will need to be applied in shaping and regulating the content moderation frameworks will be harmonized, fully harmonized by the DSA. So this is a very important step forward, a harmonized legal framework for startups. This requires that there is, first of all, a technical infrastructure for authorities to cooperate, and this is what is foreseen with a common information sharing system in the DSA, and which will need to be specified, of course, but we are already working on some concepts. And the specific procedure to ensure that when an issue of compliance with the DSA rules is raised by a member state, the country of origin takes responsibility for this, for looking into the matter, eventually ask help of other authorities and potentially also of the Commission or the board. So this is what I was mentioning as a cooperative framework, so that there is a clear allocation of responsibility, but also tools for authorities to get support in the enforcement of the rules. And this basic framework, which will concern 99% of platforms active in Europe, is unchanged or fundamentally unchanged from the Commission proposal. Then when it comes to what is illegal, I mean, the DSA is harmonizing a set of rules, which are those concerning content moderation activities. It doesn't harmonize all the legal framework applicable to internet activities. This remains subject to the e-commerce directive, of course. We envisage a framework to facilitate authorities to inform platforms, to inform and to request removal of specific content for which the platform is not liable because there is the safe harbor. But within this context, when there are orders issued by authorities across Europe with specific characteristics, those are able to identify and tackle the illegal content that needs to be removed because it's illegal according to the assessment of the authorities. And this is not changing what is already now, but it's providing through judicial orders, for instance, but it's providing a framework which will simplify the life of platforms in dealing with such judicial orders or administrative orders by authorities.
So thank you, Enrico. We understand the clear division of labor between the Commission and the Member State, and the cooperation mechanism is very clear from your side. Manon and then Venus, perhaps, what is your view on this framework? What do you think are the advantages and eventually the drawbacks, and of course also on this framework?
Thanks for the question. I think for us, there's two answers. First of all, We also have in our membership, to some extent, startups that also want to be or are close to also become VLOPs. And it's also for us important to make sure that the rules also work for them when it comes to enforcement, and that the controversial principle is not challenged also for them. And then I think to reply to your question, for us, the most important thing is that startup, they have the legal clarity. For us, the question is not about if the Commission enforces it, or if there's an agency for the Commission enforcing it, or if the member state enforcing it, or authorities in the member state enforcing it. It's rather the question is regarding if it's a country of destination or country of origin principle. And for us, as I mentioned, country of origin and the fact that you know that you will be liable or that you will respond to the authority in the member state where you are legally established is the most important thing. And if I may also comment to also what was previously said, for us, there's no, we don't see how enforcement, for example, with the country of destination system from a national perspective could work or could be efficient if we take into consideration that there's no common definition of illegal content EU-wide, and there won't be one. So I guess this is my answer to your question. And something that I also want to precise is that from our perspective, the country of origin is the backbone of the single market. If it's also what makes also the single market, and also what will create also and what is creating the digital single market. We believe that if the DSA goes against that, and we actually am happy to hear that the Commission really wants to enforce the country of origin principle. But unfortunately, as you said, the Council and both the Council and the European Parliament have provisions that are maybe not going in this direction. Well, we would see this as a threat to the integrity of the digital single market. And we believe also that it would also go against the ambition of creating this digital single market, as maybe de facto at some point online platform would not be able to benefit from a single market digitally. So yeah, that's my question so far.
So we understand your argument that says that as a country of origin principle is what the single market is. This is why we have a single market here. But let's go back to a counter argument. I'm a kind of heavy lawyer here. And taking the argument from France, they say that, yeah, but the country of destination is necessary because otherwise we'll have a bottleneck issue here, like the GDPR, where basically only some countries will enforce and the other will do anything. And basically they will have a lack of enforcement, we'll have under-enforcement, and basically the DSA will not be enforced. So what is your answer also to this argument?
I don't know if I have the answer to that, but what I can tell you from the startup perspective, from the GDPR enforcement, is that there were, at the time of the enforcement, startups were promised point of contact and support from data protection authorities for the implementation of the GDPR. However, DPAs, they did not have enough resources in time to be able to provide that to startups. So for startups, they are really, GDPR is here. Our members, they complied with it and they're happy to comply with it. But it was a bit of a scramble back in the time of the enforcement. So I would really, I don't know if I can answer to your question, but I think for us, the two lessons to take from there is that we have to make sure that the DSEs, they have what they need to follow through their duties and to cooperate together and enforce the DSA. And I think something where also, and maybe I will repeat myself, where I see a difference between also GDPR and DSA is that GDPR, it was a regulation that was identical, and DSA, you have to regulate on something where the definition of illegal content can change from one member state to another. So I would believe cooperation and make sure that also these authorities, they have the resources that they need will be also really important for the enforcement, and could also maybe reply to the problem that the French government is raising.
Venus, perhaps I'm pretty sure you have some insight about that. But before, for the agencies, you can ask questions on Slido, and we will do Q&A at the end of this intervention. So please feel free to ask every question that you want. We'd be happy to answer. Venus, the floor is yours.
Yeah, absolutely. I couldn't agree with Manon more in the sense that, GDPR, despite the fact that it was a long time coming, many member states did were underprepared, and we can avoid that now by making sure that the DSEs do have the necessary resources to be able to respond to queries, to requests, etc. And actually, it is arguable that those countries where some of the VLOPs are based will have greater resources, because it will be important for them to make sure that it runs as smoothly as possible once the regulatory transition period is passed and the law is enforced. This is all part of creating a environment where startups, scale-ups, and unicorns can continue to succeed. So really, it's in their interest that they're properly resourced and able to deal effectively with any queries. And I think this point of timeliness is really important for startups and larger players alike. The longer that these conversations go on in terms of the back and forth between member states, the greater uncertainty there is for a startup. And if you can see how that could snowball to create a wider problem for the ecosystem in that member state. So I think it's really important that those sort of conversations happen in a really sort of frank way, and that the regulators are resourced adequately to be able to sort of respond quickly. I guess to that point around defining exactly what is illegal and how platforms and startups decide to regulate that, there is concern, of course, that if there are sort of very stringent takedown times, that there will be an over regulation by startups themselves, that there actually will be just a chilling effect, which means that actually we don't see these, I'm sure we'll see landmark cases between as sort of the regulation is in play. But it may be that content is just over-regulated so as not to trigger those mechanisms. And that will be incredibly dangerous as well for free speech, for the ability of startups to scale, to grow, if they feel that they are always sort of constrained by the regulatory framework that's passed. So I think it'll be really important that there is cooperation, not just between member states, but also a really open dialogue between the regulators and the regulatory authorities and the startups and scale-ups on the ground, so that we have a good relationship rather than one that is based on infringement and action, which could lead to just sort of an over-regulation from the startups themselves.
And then we have also the court. Enrico, from your side, so you have two views, one from startup and one from mix of startup, but also other companies. How do you think that the Commission and the member state could work end to end in this aspect to make sure that the voice of those companies is, I would say, safeguarded in the best interest, that we have still the famous country of origin principle here, and that member states, when they will implement the regulation, will not have a different ruling here. Or the Commission, perhaps, will the Commission play a role here to say that, yes, but guys, we should harmonize this aspect of, for example, illegal content to avoid a different ruling here?
Yes, on this issue of illegal content and the definition of what is illegal or not, I think that this should be seen in the whole context of the DSA. The DSA is not harmonizing what is legal or illegal content. This is, there are a series of domains of law that are regulating any kind of activity, online, offline, both, which cannot simply be harmonized. There is the e-commerce directive that provides an important framework there, and that remains fully applicable. But here, I think we should distinguish what are the requirements which are applicable to the platform as such, and those are fully harmonized by the DSA and fully covered for what is not covered by the DSA by other frameworks, but also the e-commerce directive. From the legality of each individual piece of content which the platforms intermediate. Now, this kind of individual illegal content, for this content, the DSA provides a clear safe harbor. The platform should not be liable for the content which is intermediated unless it is, of course, aware and notified of its illegality. But this means that the legality of this content is not regulated by the DSA, only that the platform will have to apply due diligence when they are made aware of of such illegality, and whether this will be based on the country of origin or where a given illegal act made by a users or affecting one of the users of the platform, it's happening. This is not regulated and cannot regulated by the DSA. This remains subject to the normal rules about causality, location of harm, and so on. But what is very important is that the platform and the responsibilities of the platform vis-a-vis this illegal content are clearly framed and are based on the country of origin. So enforcement of those responsibility, due diligence obligations are fully harmonized, as I said, and they are fully under control of the country of origin for 99% of cases. Then what happens in case of dysfunctions? First of all, I fully agree, resource and independency, it's also an independence of regulator, thanks to the fact that there are sufficient resources to carry on the function it is provided. This is an important point of the Commission proposal, and I think it's only strengthened has been strengthened even in the discussion. But then what happens if there are dysfunctions in this cooperation between member states? Well, I mean, for a first element should be the regulatory community, the board, which is represented by the board, that is able to facilitate the and to recommend actions by the digital services coordinators. So this is an important point. But also the Commission as a role as a dispute settlement. This for all platforms when there is disagreement between authorities in different member states. And then, of course, for blobs, this is causing it may have a different profile of risks, those kind of platforms, systemic risk. So the possible role of the Commission is even strengthened, not only as a dispute settlement between different authorities which don't agree on how responsibilities have been fulfilled, but also as a potential direct enforcer. And I think this equilibrium, which is a new equilibrium compared even to GDPR, is one of the important elements to stress of the DSA proposal.
Thank you, Enrico, for having this very broad overview of the DSA. Maybe we will go to the next part about how the European Parliament should address the enforcement issue here. And Venus, the question is for you. What is the current state of play on enforcement before the European Parliament? And is it an adequate policy proposal here?
So I think what's before the European Parliament currently will be, we need greater clarity from the Parliament on sort of specific definitions. For example, exactly what is an online marketplace needs to be much more clearly defined, because if these things are left to the last minute, it firstly gives startups less clarity for a longer period of time. And secondly, we could start to see then differentiations of interpretation by different national authorities, by the different DSEs. So it's really important that actually where the Commission and where the EU is taking a harmonized approach, that the definitions are very, very tightly and clearly defined, because otherwise we might see those repercussions fall down later down the line. I think also one thing that we haven't really touched on yet is this idea of sort of other safeguards around out of court redress, etc. And it would be really important to make sure that that's safeguarded against, so that it can't be abused by bad actors, for example, competitors to a startup, etc., deciding to drag startups through the mud through sort of other settlement systems. So I think there's still...
If I may, on enforcement in particular, what is your view? Because I understand that the definition of marketplaces is one thing, but if you have to focus more your conversation on enforcement, what is the current state of play before?
I think those two things are very intrinsically linked, though, Christoph, if I may. You know, enforcement will only be as good as how clear the rule book is itself. And therefore, it's, you know, unless we get to the bottom of that, then there will be problems with enforcement down the line. I think, for example, you know, the enforcement framework of taking a process-based approach rather than a content-specific approach is a good one, and it's a principle that we should hold on to. I'm speaking to you all from the UK, which is currently also developing its own framework to regulate the online world. And in the UK, they've taken the approach of looking at both illegal and lawful but harmful content. So whilst we're only looking at, you know, internally at one nation, we've actually made life far more harder for ourselves by taking this very vague approach. And so I think, you know, a lesson that the EU could learn from the UK is actually to be very clear, super concise, super well defined, etc., and to take that sort of principle-based approach that looks at process over content, which, as Enrico says, you know, is the found, like the eCommerce Directive and intermediate liability is the foundations for a thriving internet ecosystem in Europe and beyond. So it's important that we cherish that. So in terms of the current state of play, I think, you know, we are sort of slowly, gradually inching towards an answer, but I think there are still huge unknowns which could have ramifications down the line in terms of how effective this enforcement is. And I think, you know, workability and effectiveness needs to be sort of front of mind as legislators make their decisions in the coming weeks and months.
Yeah, it's funny because the UK left Europe, and right now everyone is looking to the UK also on the DMA. Apparently, it's a very good proposal too. So, what is your view, Manon? Do you have some insight about the benefit of the European Parliament proposal, and what change do you recommend for startup to ensure the growth of startup across border?
Thanks for the question. First of all, I just want to say that I agree with what Venus just said regarding having clarity when it comes to definition, and that it's also the basis. Something that, before replying to I mean, it's also a component of your question regarding enforcement, and something that I just have in mind I want to mention is that when it comes to also actual knowledge or awareness, all this concept that was inherited from the eCommerce Directive, it's also really great to have also clarity when it comes to that. Just something that I wanted to mention. But to reply to your question, I think in this discussion we've seen that the Commission moved forward and had like a concrete controversial in principle proposal in the DSA. Then the European Parliament is a bit tweaking it, and the Council too. And so regarding the European Parliament, some of the things that I've seen, that we've seen also on the many draft reports, opinions and compromise amendments, is that I've seen something that was like really concerning for us. That was that the DSC in charge of so the Digital Service Coordinator in charge of issuing the order should be also the one in charge of enforcing the order, regardless of where the platform was established. And I think it was also linked with giving also a platform a mere translation of the order in question. So if I may, just to add clarity to my answer, if I may just use a concrete example of a startup just to emphasize on this. So imagine you are a Danish tattoo platform, one of which is called Tattoo. I don't know if you've ever heard of this one, but it's the biggest tattoo community in the world. It's a Danish startup, and they have like a big stock of library of tattoo design, tattoo picture, but they also have like a booking services. So me, myself, Manon from Belgium, I can book, if I want to have a tattoo somewhere else in the world, I can just book it from there. And I know that the person I will use to book it, the tattoo artist that I will use, will be reliable. So what I also mean is that this is one of the many examples of where also startups bring more choices and also reliability for consumers. And so just imagine you are a tattoo do, and you're Danish, you're getting an order from France with a probably of translated order in Danish to remove a piece of content. And then you receive another one from Spain. Same story. You receive this order, but it's not fully translated into Danish. So you don't know, there is no two problems. You don't know to which extent you will comply to this order because you don't understand it completely. And also maybe you can realize that you don't know also if this order is or is not really fully aligned with what is legal or illegal in your own member states. What do? If you're startups, you will not take the risk. You will not risk liability exemption, so you might remove it. And so this is also this is a point that Venus also mentioned, that there might be over removing of perfectly legal content. And so for us, when we see some of the proposal from the European Parliament, we are really worried because it will create legal uncertainty for startups. Because as I mentioned, and as Venus mentioned, they don't have the resources to treat requests or orders from all authorities from several member states. And especially if we follow some of the compromise amendment put forward by the rapporteur in the EP, they might not have also the fully translated order. So for us, enforcing the DSA like that will not be efficient. And also, as I mentioned, in the worst case scenario, it will maybe force a startup to remove a perfectly legal piece of content, which is not what we want, and I don't think is what also the DSA wants to achieve. So in terms of recommendation, I think the main recommendation I can say, and that I will keep saying, is that we should not undermine the country of origin system. It did surprise us. I mean, we understand to some extent why some member states would want to undermine it, but it was really a big surprise for us when it came from the European Parliament, which is a strong supporter of the EU and a strong also supporter of the internal market, to undercut this principle. And so yeah, just to sum up, our recommendation as AFS is that we don't want this principle to be undermined. We believe that if it would be undermined, it would be also undermining the idea itself of having a digital single market. And here I'm repeating myself. We also believe that it will make it harder for startups to scale their business and compete with other players in the EU. And at a later stage, we also believe that it will diminish the digital opportunities in the EU markets for EU businesses, but also for EU consumers, because it will mean that less companies or less startups will be able to emerge and scale also in the digital markets in the EU. So yeah, these are our recommendations. So keep the country origin system, basically. You muted, Christophe.
Sorry, again. So I think nobody wants to move again from this principle right now, but because we have this French proposal a few months ago, but right now nobody wants to depart from the country of origin principle, including France, apparently. But we'll see perhaps in the next few months if this is still the case. And from your side, Venus, do you have any insight on how we should improve the regulation and the enforcement part?
So I think, I mean, really, I could only repeat what Manon has already said, in the sense of, you know, I think it is really remarkable that the European Parliament would seek to undermine principles that, you know, the digital single market is something that is still in process. We cannot say that we've fully completed it, and that should be the ambition, because startups really do want to sell and have customers right across the European Union. That's one of the greatest strengths of the European Union, is that it is a market of 500 million, rather than, you know, of any one small, particularly member state. And some of the digital front-runner nations have only become so because they are part of a single market. You know, we represent countries like Ireland and Denmark and Finland, and frankly, you know, these countries do not have huge markets internally, but being able to operate right across the EU has allowed them to flourish. And we want, you know, no one to be left behind in this development. We want to see 1,000 flowers bloom right across the EU, and that can only be done if we have greater harmonization of rules. And so I would, you know, stress the need to maintain the country of origin principle, but also to look at other ways in which there can be greater sort of harmonization and understanding of the regulation for startups. You know, it should be something that keeps folks in the Commission and the Parliament up at night, that only 5% of startups feel that the EU understands their needs. And yet our focus to date, whether discussing the DSA or the DMA, has always been on the larger tech players. And so I think, you know, a greater attention to the needs of startups and scale-ups and how we can create more in the European tech ecosystem is really where those sort of innovative regulations should be coming from, rather than trying to sort of tear down or put up barriers elsewhere. So I guess I will just leave with that thought, because Manon articulated so beautifully, you know, many of the same requests that we have.
So interesting view, Enrico. I know I cannot ask the question how we should improve, because you are on the Commission side, so it's a little bit complicated for you to have a view on how we should improve the European Parliament proposal here. So I will take the Q&A. We have 4 questions already. So for the audiences, you can ask questions on Slido, and we'll be happy to answer them. So the first question is, consumer protection is important for a sustainable commerce environment. Shouldn't offline and offline business follow the same rule? So we want to take the question. Perhaps Enrico, you are the best place for that question.
Yes, I think that this is a principle that is not undermined or touched by the DSA, and actually strengthened. Consumer protection rules are applicable to all activities in Europe. Of course, they should tackle who is responsible for the sale, for instance, of goods. This is the main responsible to ensure compliance with those rules. Of course, the platforms, they can play a role, in particular in ensuring that traders which are using the platforms can be traced, and are the identity of those traders is checked by the platform. This is what is underpinning the Know Your Business Customer rules, which are included in the DSA. So to answer your question, yes, I think that offline and online that consumer protection rules should be applicable offline and online to all the actors. And the DSA is meant also to facilitate this compliance and with these rules.
I have a very good question from the audiences, and perhaps this is for you, Manon. The argument is good. If you sell in a country, let's say Denmark, shouldn't be normal that you follow the rule here there. So in Denmark, even so imagine you are a startup in France and you sell a product in Denmark. Why you should not follow the rule in Denmark if you sell a product in Denmark?
But I don't see why you would not follow it if you sell your product in Denmark.
No, but the question is, if it's a country of origin principle.
Yeah, of course. But if you're startups and you were selling in Denmark, if you were following the rule, the principle of controversy is to know that if there is an issue where you would be liable is the place where you are established legally, where you would have to respond to the authority. Does that reply to the question?
Correct. Perhaps the person behind the computer will follow up. We cannot have an interaction, but I guess it will be interesting to have him on board. So another question perhaps is for you again, Enrico. Most illegal content is already harmonized in the EU GDPR, copyright, dangerous product, and so on. What impact or workload will the DSA have on national authorities? Because when we speak about enforcement, we should speak about resources, and the question is about basically what kind of resources a national authority should have. And if you have also some view, I will broaden the question about the number of staff at the Commission for the Relational Platform. It would be great to have your view on that.
Yes, again, I think we should distinguish the legality of individual content, which changes the rules applicable. They change also depending on the domain of law which we are speaking about, and the rules applicable to the platform as an intermediary. This, I think, it's a very, very important distinction to understand the whole architecture of the DSA. The individual illegal content may be subject to different regime. Copyright, for instance, is not covered by the eCommerce Directive, and subject to specific rules. The legality of such a content often is to be defined by a judge, and it is left to national legislation, because really we are speaking of a large variety of situations, defamations, child sexual abuse. I mean, we have all kind of counterfeiting, illegal streaming, very different kind of individual kind of content, or even services which may be legal under different legal frameworks. And the aim of the DSA is not to harmonize this. This should be clear, I think. It would be an impossible task, and would overlap with many other areas where sector-specific legislation is applicable, and there are specific instruments. What the DSA is doing is to harmonize, fully harmonize the rules and the enforcement of the responsibilities that the platform have vis-a-vis a potential illegal content. This is what is important. And for this, we think that it's extremely important that the country of origin remains the basic tool, exactly because we are not discussing whether a specific toy is dangerous or not. It may well be, and this should be tackled by the market surveillance authorities, for instance, a specific toy sold in a marketplace. But we should look on how the marketplace reacts when there is awareness or there is a risk that such a toy is sold through the marketplace. And this is where the harmonization effect of the DSA, we believe it's important, but that's why it should be done centrally in the country of origin, of course, for the large majority of platforms. This is untouched in all in different proposals that we have seen. But in any case, any deviation to the country of origin could not lead to a full fragmentation, and this it's important. If the systems and processes of platforms in moderating content were subject to 27 different potential systems, this would be very difficult to handle.
But in terms of staff, how do you?
Yes, your second question. I didn't try to avoid it, but I mean the DSA already envisaged there is a financial fiche attached to the proposal where we spelled out the assumptions for engagement of staff at the European level, so the board, and in particular the support to the board and the direct activities of the Commission. With regard, so this is where, on the basis of the assumption of the original proposal, where we spell out what should be the Commission role. Of course, I mean, those are the assumption of the original Commission proposal, where the role of the Commission was more a residual one, as a supporting role. Any change that the co-legislators will agree on will need to take into account that this has likely impacts also on those assumptions, and therefore they will need to be reviewed.
Venus and Manon, do you have some reaction about that?
I would just add one thing. You know, these costs can spiral out of control if everyone doesn't approach the issues. I mean, as Enrico said, you know, the DSA's proposals are incredibly broad in scope. And so proportionality and necessity will be incredibly important from all the DSEs to make sure that the actions that they are taking and the flags that they're raising are proportionate to the risk out there. And this will be, you know, extremely important to SMEs in particular, because as Manon has previously said, you know, their resources are incredibly limited, but it'll actually be as important to the DSEs not being overwhelmed. And so, you know, you can have budgets that could end up being stratospheric unless everyone takes sort of a very sort of proportionate and sensible approach. And so we'd really like to see sort of early coordination of efforts and cooperation to understand exactly, you know, where that line is drawn. And obviously we turn to the Commission to help set those rules and set the framework that we can all then operate underneath. So I would just add that one point.
Thank you, Manon. Do you have any reaction about it? No. So we do 1 minute left. We are on time. So if you have a closing remark, 30 seconds, no, not 30 seconds, but a few words about this topic, what will be your last word? Manon first.
Thanks. Well, I think I will just repeat myself, but we believe at AFS that the conversion principle is of paramount importance, and it's the only answer to enforcement, if I may say it like that. We are afraid that undermining it or mixing it with country of destination provision as it's been put forward either by the Council or the Parliament's position for now, would be also going against all the efforts of building a digital single market.
Venus?
I would just say in very sort of quick terms that, you know, we're entering a crunch period right now, and it may lead to just sort of louder voices being heard more, but startups are incredibly important to the tech ecosystem. And so as we enter sort of these like final phases, it's really important that their voice doesn't get lost in the negotiations, because, you know, that's where Europe's future growth and innovation will come from.
Okay, thank you. And Enrico for the final one.
The Commission is looking forward to look to the position of the co-legislators, and will give all its efforts to ensure that this proposal is agreed in the shortest possible time, because we believe that this is an important piece of legislation and important for Europe, for European citizens and businesses. So we are ready to help here, really, to ensure that sustainable legal framework is put in place as soon as possible.
So thank you very much, everyone, for your contribution and for your time on this panel and this event. So you will be able for the agencies to review the event on your YouTube channel, but also on your website, datainnovation.org. And so please feel free to ask us a question by email if you have any. One, we'll be happy to answer. Thank you again for your time, and enjoy your afternoon.